On to our next top story. The judge in the George Zimmerman murder trial has issued rulings about what the defense can show and tell jurors about the 17-year-old Trayvon Martin and the night of his shooting. The coverage of the killing of Trayvon Martin and the trial of George Zimmerman continues, and we begin with key testimony for the defense from a private forensic expert. Anthony Hill has more.
Defense witness Dr. Vincent DeMaio says forensic evidence is consistent with George Zimmerman's story. The pathologist told the court gunpowder burns show Trayvon Martin was over Zimmerman when he shot and killed the teenager.
The clothing was 2 to 4 inches away. It's consistent with somebody leaning over the person doing the shooting.
That is how Zimmerman described events to police after the shooting.
He was on top of me like this, and I shot him. And I didn't think I hit him because he sat up and he said, "Oh, you got me."
DeMaio also said the teenager could have lived up to 3 minutes after being shot and could even have moved his arms under his body after Zimmerman had spread them out. The state also argued the victim could have been backing up when he was shot.
Zimmerman on the ground, and you would have the same angle. He's pulling away, and Zimmerman's shooting him at that time.
Yes.
The prosecution got DeMaio to admit he's being paid $400 an hour for his work for the defense. But forensic consultant Michael Knox says the doctor's testimony was still effective.
What the defense just did is they brought in a forensic expert who has tied all that evidence together and put it all in one package, and that's really compelling to the jury.
Defense attorneys say they could finish presenting their case on Wednesday. Anthony Hill, Arise News.
To help us watch the trial today, we have former prosecutor Gary Casimir, as well as trial attorney Jennifer Zedalis, who is with us via Skype from the Levin College of Law in Gainesville, Florida, where she is a professor. Always good to see you both. Thank you both for joining us. Appreciate it. Okay, so yesterday was a long day in court. It was a 13-hour court session.
Amazing.
And part of the reason it went so long was that there were some hearings at the end of the day about what could be admitted as evidence. The defense wanted to admit text messages from Trayvon Martin talking about fighting, and then also want to, of course, admit their recreation animation about what they say happened on that night.
Yes.
So the judge ruled this morning.
Yes, this morning the judge ruled after 12 or 13 hours of working the day before that the animation would be only received as demonstrative evidence, not as evidence in the case in chief. And what that means, and the jury cannot use it to take it back to the jury room and deliberate with it and see it over and over again, as they can take other pieces of evidence, anything that's been admitted in the case. What they're saying is that this is a creation by the defense of how they see things. So because the judge was afraid that somehow the jury may misinterpret this as fact, he limited that. He limited their ability to have access to it and see it over and over again.
Jennifer, and I understand that they can't, that defense cannot enter this as evidence, but they can use it demonstratively. But doesn't that sort of ring the bell?
Well, yes, it does. It absolutely does, Deborah. But it's still a distinction. I think that the judge is going to allow the defense to use this animation to support their arguments based on the facts and their inferences that the defense is drawing from the facts. So I think she wanted to give them an opportunity to try and use this wonderful visual aid from the defense perspective. But she didn't find that it possessed the necessary criteria to be offered into evidence, as my colleague just mentioned. If it's formally received into evidence, that means it actually goes back into the jury room with the jurors, and they consider it as something that has been proven. In this case, she's going to permit the defense to use it as a visual demonstration based on, again, their theory of what happened. And, so I think that she did the best she could with the evidence that was presented and, the legal issues that are involved in this.
Well, help me understand, either of you, Jennifer or Gary, why she ruled that these text messages that were found on Trayvon Martin's cell phone about fighting could not be entered in as evidence. Why can they not be entered in when the 911 calls that George Zimmerman has made previously is allowed in, as well as there was testimony just this week about his fighting lessons, sort of his history. Mm-hmm. Why is it okay for that and not okay for the text messages?
Well, I think in this instance, what the court wanted to do is limit the communications because he found them overly prejudicial, unduly prejudicial here, in the sense that the evidence seems to suggest a propensity to do something, to be violent, or to be misconstrued. The defense really wanted to get this evidence in because they wanted to take a picture of Trayvon not as a little boy, but someone who may be into fighting and not afraid of fighting, wanted to get guns. That paints a different picture in the juror's mind of who we're dealing with. So this was very important to the defense and a big loss for them. But I think the judge here did the right thing in the sense that I don't think they made their case that this was something that played a role in this incident in and of itself.
And oh, by the way, they argued very hard for this and late into the night. In fact, the court day ended abruptly with the testimony, after the testimony in the trial of George Zimmerman, when Seminole County Circuit Judge Deborah Nelson turned her back on the defense lawyers while they're still talking, protesting the 12-and-a-half-hour workday. Take a look at this.
I'm not getting into this. Court is in recess. I will give my ruling in the morning. I'll see you at 8 o'clock in the morning. Court is in recess. It is
it's 10 o'clock
9:56. No, court is in recess. Thank you very much. With all due respect, we'll see you at 8 in the morning.
Man, Jennifer, she was finished. And of course, Don West continues to try to make his argument. Is this unusual that a judge will say, listen, I've heard enough, I'm not going to hear anymore? And she just walked out even while they were still talking.
It does happen, Deborah. This is a trial that's gone on for many days. The judge and all of the attorneys on both sides have been in that courtroom from, early in the morning. It's typical for the attorneys, of course, to get there early until well after the jurors have been excused. And Judge Nelson did, of course, let them know in no uncertain terms yesterday evening that she was ready to adjourn for the day. It does happen, but typically just, when you have lengthy trials like this, it's everyone's worn a little bit thin by this point.
Okay, let's move on. Let's talk about the big witness of the day yesterday, and that was Vincent DeMeo. He is a forensic pathologist, an independent pathologist that the defense brought in to talk about the evidence as it relates to Trayvon Martin and that gunshot. Gary, let's start with you. He seemed to be very, very effective.
Yes, he's an effective witness. He's a very well-renowned expert in his field. I mean, in terms of the prosecution, he's testified for a lot of defense before in the past. That's how they try to diminish his quality. But some of the evidence he was given, the scientific evidence, is very hard to rebut. It's very well known that if you have a shooting from a certain range, a short range, what they call a contact wound, gases will be released, calling stripling, and that causes a certain marking either on clothing or on your skin itself. And this is not easily refutable. But what they were able to score, the defense in this instance, to the extent it's a score, to show that Zimmerman was on the bottom and Martin was on the top. There's been a lot of discussion about this. And I think this played a major role in the defense being able to show that Zimmerman was more in a submissive position and that Martin was on top.
And to that point, Jennifer, though, the prosecution did come back on cross-examination and get the doctor to admit that Trayvon could have been pulling back, could have been pulling away when he fired the shot. Was that enough to neutralize the effectiveness of his testimony?
We won't know until we see how the jurors deal with this. The defense absolutely scored some points with Dr. DeMeo. I think that the state attorney did a good job focusing in on areas during cross that are helpful to the state. But remember, all the defense needs is a reasonable doubt. The state does have the burden of proof.
Here's the issue with the pulling away, which I think the prosecutor did a very good job of suggesting, but here's what it suggests, that the fight was over, that he was trying to get away from him. But this is the problem you have here. Then you have a situation where two people are on a fight and then somebody uses more force than required, of course, to repel violence. Is that a murder too? That changes the facts of the case that they're presenting. This turns the case into more of a manslaughter situation.
And that brings up the topic that we've been talking about all along. And what is the chances that the jury will be allowed to consider a lesser charge? And this might open the door. I think it definitely opens the door. I don't think they can avoid it. I think it's, and I understand that in Florida, and the professor can speak more on this, that the sentence may be the same. So, which is another issue the defense may be worried about. They may not want the manslaughter at all and just put the murder too, so they can get a full-out acquittal. But here you have a situation where the prosecution is more saying there was a fight, he was on top, maybe he
was pulling away, which suggests that, you know, the fight was over, you didn't have to do this, you went too far, which generally calls for a manslaughter conviction, not a murder too. So, you know, in these instances, so we have, you know, it's a very tough issue for the prosecution right now.
It is indeed, and of course the trial is ongoing. There's a witness by the name of Ruth that is up testifying right now. Looks like the defense is questioning them. But just to talk while we're looking at this picture, the defense has told the judge that they expect to rest today, that they expect to be finished today. So that means that that closing arguments will begin. Who gets to go first, and what difference does that make?
Well, in Florida, and the professor can speak about this, what happens is the person with the burden usually goes last. So the prosecution would end up going last because they have the burden in the case. I'm not sure, in California sometimes you have a rebuttal opportunity. In Florida, I believe they do have an opportunity for rebuttal. I'm going to ask the professor to clarify that
So
issue.
jump in there, Jennifer, about who goes in what order.
Actually, in the state of Florida, our procedural rule changed about 3 or 4 years ago. The state attorney goes first. The defense comes second. The defense, of course, does their closing argument and their rebuttal to the prosecution's argument. And then the prosecution gets to have their rebuttal to the defense. So the defense is in the middle, the prosecutor goes first, and prosecution gets rebuttal. Prior to the change in the rule, the defense, the order changed depended on whether or not the defense called witnesses. But it's the state goes first, and the state gets rebuttal.
So, and I would imagine whoever gets the last word, that's a catbird seat. That's preferable, yes?
Yes. Well, the idea is you have the burden to overcome and prove reasonable doubt. So they say you get the last word to be able to get over that burden.
And very briefly right now, we'll talk about this also a little bit more later on in the show, but the judge also spoke directly to George Zimmerman yesterday, making sure that he knew his right to testify in his own defense, and informed him that his attorney should be discussing this with him and that she would ask him about that later to make sure that that had happened. Is that standard, Jennifer?
Absolutely. That is standard. That will be done on the record. That is so that it is clear from the record that the defense attorney had those conversations with their client, and that there's a showing from the accused person, the defendant, in open court on the record, that they understand that that's their decision, that's their call. Of course, you know, we advise our clients whether they should testify or not based on our view of the case, but that is absolutely a decision that belongs to the accused person.
All right, Jennifer Zedalis, Gary Casimir, you guys sit tight. We're going to come back to you after we take care of some other business news of the day. But thank you so much for this discussion. Talk to you again in just a little bit.
Thank you.